The most important thing for you to learn about judicial recusal is that it is based on an honor system, and I think that that needs to be fixed. The Supreme Court is in charge of the honor of the administrative arm of the entire federal judiciary as far as the judges are concerned, and they need to do their job. Every case in which a judge should have recused themselves, action needs to be taken on. One of the largest cases that has gone underreported is the third largest Ponzi scheme in U.S. history. That's the Tom Petters case. Think about how much power and how many, in fact, the main attorney received over $2 million out of a $4 million allowance from the insurance company to represent Mr. Petters in the case. In my opinion, he did a horrible job. He did a horrible job on many avenues, and one of the biggest ways is that during the jury deliberation, the Judge Kyle, admitted to changing the indictment that he gave to the jury. He eliminated the co-defendants. Anybody that understands the law understands this is a massive problem on many levels, because to eliminate a joint defendant on a joint defendant indictment means you have absolutely destroyed the probable cause for the defendant, and therefore that person is no longer a defendant. They are, or they could be, considered just a civilian or a target. Nothing was done about that. That is a huge problem, because Mr. Petters is in jail right now. And one of the major reasons I believe that he's in jail right now is because Judge Kyle took the case. Why does it matter that Judge Kyle took the case? Because at the time Judge Kyle took the case, a $13.5 million lawsuit around the Petters case was involved with Judge Kyle's son, heir apparent, named also Judge Kyle. The son has the same name, but junior, as the judge. And Judge Kyle did not recuse himself, because how would he have had power over the case to make sure that his son was safe, to make sure that his money was safe? Because if his son has to pay some money, where is it going to come from if his son doesn't have it? Judge Kyle oversaw the Tom Petters case. Judge Kyle should have recused himself, and the Supreme Court of the United States should have stepped in. Tom Petters is in prison now, not because of a fair trial, but because Judge Kyle admitted on the record to whiting out the indictment that he gave to the jury. The jury was confused about the indictment. He also illegally. It was a joint defendant indictment, which means that there is only probable cause found by the grand jury against those joint defendants. To separate out those joint defendants, you cannot do that in a joint defendant indictment unless you find probable cause per each defendant independently. That was never done in this case. And it was also never changed within the time frame of the grand jury sitting, and another grand jury was not reconvened in order to find out if there was probable cause against Tom independently. Judicial recusal is not just some theoretical thing that we're talking about. Judicial recusal, I believe, when it is not properly handled by the judge, when the judge does not have honor to recuse themselves when they should appropriately, and when the Supreme Court does not step in and recuse and correct the wrongs that have been done because of a judge not recusing themselves. People are in jail. Money was taken. People are in jail. That needs to be fixed now.
Editing Jen here. I realized it might be helpful to receive some documentation at the end of this video, so I am attaching 2 bits of documentation. The first is going to be part of the recusal argument for a filing that I submitted in violation of the Judicial Conduct and Disciplinary Act of 1980, as well as a statement from a testimony from a leading expert in this industry indicating that Judge Kyle should have recused himself. So the document that I wrote says recusal, and this is on page, I don't know what page it is. I did a screenshot so that I could say it for this. Judge Kyle's judicial misconduct started when he accepted the case, a case in which his son has and has continued to have a huge economic and non-economic interest. Judicial Canons 2B's commentary clearly states, quote, "A judge should not use the judge's judicial position to gain advantage in litigation involving a member of the judge's family," end quote. And I put different dots in between if I was summarizing what they said, so I didn't include every single word. But the spirit is still the same. A judge should not use the judge's judicial position to gain advantage in litigation involving a member of the judge's family. Judge Kyle's actions not only cut within the letter, but the spirit of Judicial Conduct and Disabilities Act of 1980 and Judicial Canons 1, 2, and 3. The United States Supreme Court Justice Breyer's September 2006 report highlights examples of when valid inquiries are proper, pages 45 to 46. In this case, at the very least, a limited inquiry is appropriate prior to dismissal because the transcript previously attached reports Judge Kyle's admitting on the record to manufacturing the original indictment, giving a manufactured indictment to the, quote, trial jury, group of people that based on his power, he was able to get together and make it seem as though he was swearing in as a jury, but because it was a manufactured document that he had, it was just theater that has the consequences of real life, and using it as the basis for Mr. Petter's, quote, sentence. Standard 4 states that there should be a limited inquiry if the allegations are capable of being verified by looking at identifiable transcripts. Pages 47 to 41 also cite examples when allegations may be verified by transcripts or the court record, as is proper in this case. In the Tom Petter's case, you have what we're saying can be easily checked on the record, and so that's the limited inquiry that he was requesting that he was denied. Needs to be relooked at. Chief judges were found to have improperly dismissed judicial complaints, and I believe a review of the Supreme Court Justice Breyer's report will provide commentary to enable the dismissal here to be cured. Pages 48, assessment. The dismissal was inconsistent with our standard 4. Transcripts may have captured the alleged interchange. Page 51, assessments. The dismissal is inconsistent with our standard 4. The complaint's allegations could have been investigated by resort to the record and transcripts, page 48. So what I'm doing is the report indicated when it is appropriate for a limited investigation to occur when it's in the record, and they keep citing that, and that's why I'm saying that his case fits within what they're talking about as a fair time, as a fair case, as fair set of facts, to do a limited inquiry into just the record. Only the record, we're not asking for anything else, and the committee report says they think that should be a limited inquiry in situations like this. Assessment Standard 2 says that the only circumstances in which the act may be applied in a recusal matter is when the judge knew he should have recused but deliberately failed to do so for illicit purposes. And in this situation, the illicit purposes are to protect his son from a case that was against him at the time that the judge accepted this case. In this case, we allege there were implicit purposes, and that was to financially protect his son and his son's law firm, his reputation as his son's father, and reduce the chances of malpractice claims and clawbacks, which are currently taking place anyway. The fact that they are still happening does not negate his illicit intent to try to avoid them from the outset. So I attached that. And then the next thing I attached is a declaration from Richard E. Flam. And if you read the declaration, you'll see that he declares, number one, that he's an attorney, and he talks about that. He explains how in paragraph 2 that he's a practicing attorney. From paragraphs 3 to paragraph 7, he helps the court understand his level of expertise in this area and that his opinion does make a difference as an expert in this area. And then number 8, he says, I am informed and believe that Judge Kyle's son was a partner in the law firm of Fredrickson and Byron, PA, at the time the firm handled all of the defendant appellant Petter's business legal needs. I am further informed and believe that Fredrickson and Byron subsequently settled a clawback suit for $13.5 million as a direct consequence of its representation of Petter's companies. Mr. Petter's does not bear the burden of proving that Judge Kyle was biased against him. A judge is required to recuse himself if any reasonable person might question the court's ability to be impartial. It is my opinion that a reasonable person might question whether Judge Kyle could preside impartially over a criminal case involving Mr. Petters, given that Frederickson and Byron, his son's law firm, not only represented Mr. Petters' companies, but suffered a substantial financial loss as a result. And Richard E. Flamm declared under penalty of perjury under the laws of the United States and of the state of California that the foregoing is true and correct on the first day of December 2014 in Berkeley, California.